Posted, February 28, 2019, 4 hours 37 minutes and 21 seconds PM MST updated, February 28, 2019, 4 hours 39 minutes and 4 seconds PM MST. Douglas County Sheriff Tony Spurlock, middle, with Boulder County Sheriff Pelle behind him, addresses members of the media on Feb. 14 in the West Foyer of the Colorado State Capitol. Helen H. Richardson, The Denver Post. Douglas County Sheriff Tony Spurlock does not want to take anyone's guns, not unless a judge has been convinced through evidence presented in a sworn affidavit and during a hearing that someone poses a significant risk to themselves and others. That not only is reasonable, it is critical. Spurlock is one of the only Republicans publicly supporting House Bill 1177, which would create what is known as an extreme risk protection order in Colorado. It empowers a judge to grant an order and a warrant to local law enforcement to confiscate the guns of someone deemed to be a danger. This legislation has been carefully crafted by Reps. Alec Garnett and Tom Sullivan and Sens. Lois Court and Brittany Pedersen to make certain it is not abused. For Spurlock, this is personal. He believes had this legislation been in place in 2017, it could have saved the life of Deputy Zachary Parrish, who was shot and killed that December after Parrish and other deputies tried to help Matthew Reel, who was suffering a mental health crisis. Spurlock's department had been contacted by Reel's mother before the incident and she wanted help. It's often the case that law enforcement's hands are tied unless an individual has actually done something illegal or has made a direct and credible threat. Parrish did everything right in the encounter with Reel, but when the deputies were called back a second time, Reel opened fire. Spurlock told us that in the past 5 years he can think of a handful of cases where there were clear signs an individual was a threat, and had his deputies been able to intervene, a tragedy might have been avoided. You don't ever know if you're going to save a life, but why would we not try to do something? If we aren't going to try to make the system better, then why are we even talking? Spurlock asked rhetorically, sharing our frustration at the opposition to this bill. Opponents are making some wild claims. For example, it's possible someone might file an extreme risk protection order out of a vendetta to try and take the guns of an enemy. But we must trust in the skills of our law enforcement to investigate and the judgment of our courts to consider whether there is a preponderance of the evidence that someone is a real danger. It's true that all of that occurs without the defendant being notified, but of course, that's the case. Nothing good could come of a mentally unstable individual who is making threats of violence being notified that someone has filed an extreme risk protection order. And it's only temporary. Within 14 days of the guns being seized, the respondent will get a day in court with legal counsel, which will be provided by the state if the individual cannot afford a lawyer. A judge will get to hear from the person whose guns were seized and needs to find clear and convincing evidence that the respondent is indeed a threat by particularly looking for a pattern of recent credible threats or acts of violence, domestic violence convictions or violations of restraining orders. Once a full 364-day protection order is granted, a person can petition the court to get their guns back early. The burden of proof to have seized property returned lies on the individual instead of on the state at that point. This individual has already been deemed a threat through due process and is now trying to have the temporary order lifted early. It makes sense for them to have to prove their condition. Like Spurlock, we don't know for sure that a red flag law like this would have stopped tragedies like those that occurred in an Aurora movie theater in 2012, an Arapahoe High School in 2013, a Colorado Springs Planned Parenthood in 2015, a Centennial neighborhood in 2016, or an apartment complex in Douglas County in 2017. But we're willing to try something now that could have worked then. The Denver Post.